Hey everybody, John Skiba here from the Arizona Consumer Law Group. I'm also founder of the Consumer Warrior Project, which is something I put together to really help people with information who are dealing with serious debt problems. And on today's video, I wanted to talk about something I read online recently that I thought was really interesting. And that is, there is a federal judge that's very well known amongst attorneys. His name is Richard Posner, and he was a judge on the Seventh Circuit Court of Appeals. And he recently retired, fairly abruptly, some people say. And it was interesting to hear the reason why he retired. He was 78 years old, so it shouldn't have been too big of a surprise. But he retired, and he said that one of the reasons he did is because he was troubled by the way that the court, his court, the Seventh Circuit Court of Appeals, treated pro se litigants. Pro se litigants are those people who are going through the legal process without attorneys. And what he said is that the court didn't treat them well. They didn't respect essentially the positions they were taking, and they didn't treat their cases like they did those cases where someone was represented by an attorney. And it got me thinking about how cases are dealt with more locally here in Arizona, where I practice law. Do courts treat pro se litigants different than they do the parties that are represented by counsel? And the question, or the answer to that is, unfortunately, absolutely yes, they are treated much differently. And the reason is, I can see the reason why the courts often do this, because pro se litigants essentially make the judge's job more difficult. In going through a civil case, debt collection, even a simple credit card case, there's a lot of procedure and process involved in handling a lawsuit, whether you're filing the lawsuit against someone else or whether you are defending yourself. There are a lot of rules in place that you have to follow, and if you don't follow them, the process doesn't go as smoothly as it can. And that creates more work, creates more issues in a case, and that means that the judge and the judge's staff are going to end up doing more of that and kind of trying to push the process along. So, and I can tell you, I do a lot of work in Arizona's justice court system. Those are cases where the amount in dispute is less than $10,000. This is where you see a lot of the eviction hearings. Almost all of the eviction hearings are held in the justice courts. See a lot of the debt collection lawsuits, which is what I deal with, by junk debt buyers, like Portfolio Recovery, Midland Funding, those types of companies. So we see a lot of those in the justice courts. And so because of that, I'm there quite a bit. And, we often will sit in the back of the courtroom waiting for our case to be called, and I see a lot of people who are representing themselves and the way that their case is handled. Now, a lot of this falls back to the person who is representing themselves in court because simply they're not prepared like they need to be. Arizona law says if you're representing yourself in court that you have to have it's assumed that you're going to have the knowledge that an attorney has when they're presenting their case, which seems to be an unfair standard because someone like myself who's a practicing attorney, I do this every day, all day, and assuming that someone else that come in representing themselves is going to be able to do that to the same level, it just doesn't seem to be a reality. So, judges treat it different. Some judges will help pro se litigants along and kind of walk them through the process. Other ones are very harsh. We see this more in the Superior Court, where they will hold them to that standard, and if they don't meet it, it can have really significant consequences, negative consequences, for their case. So what I wanted to do is give you really 3 tips if you're representing yourself in court, if you've been sued by a debt collector, if it's something where you are maybe you're pursuing a claim, or if there's some kind of eviction hearing going on. I wanted to give you 3 tips that can help you to get a better result if you are representing yourself, something that is difficult to do. The first one is that you have to be prepared. It takes a lot of time to get yourself up to speed, not only on the rules, but on the substantive law of your case. And so I tell people you can't just walk in there and expect it to be, like something you see on TV, where each side just kind of tells their side of the story and then that's it. There's a lot of procedure, there's a lot of rules going on that you need to be aware of in order to successfully defend your case. That means that you're going to put in some serious time in doing so. I see a lot of people that come into my office for consultations that are representing themselves, and I do a lot of consulting as well, or legal coaching, where I help people. What they don't realize is that even a simple case can overtake their lives. I mean, after work every night, you're going to be putting paperwork together, you're going to be reviewing statutes. There's just a lot of things that you're going to have to be able to do to get yourself up to speed. But if you want to be successful, you've got to be prepared. We offer at my office, like I said, legal coaching or legal consulting for people who are representing themselves. It's kind of an alternative to actually a full service representation, and gives you the information and really someone like me to bounce ideas off of and to kind of guide you down the path of the procedure to make sure that you don't make any mistakes there. The second thing is you're going to have to be pretty assertive. The courts may be dismissive of you and your defense or your claim, just simply because I generally see that when people are representing themselves in court. That usually means you're going to have to be more assertive in making sure that your points are coming across to the court and that the court follows the rules as well. Because sometimes they will gloss over things with a pro se litigant, and you need to make sure that the court is holding the other side's feet to the fire on that. It also may mean that you have to press the issue further. Sometimes there are appeals you have to take and have other judges look at it. It kind of goes right along with this, this assertiveness that you need to be willing to push your case along and make sure that the court respects what it is that you're doing. So it's not an easy route to go. It's something where I always tell people if you can afford counsel, it's generally going to be better for you in the end, which I know is a very self-serving thing of me to say as an attorney. But I also, like I say, at my practice, we offer everything from coaching services. I offer even online courses. You can learn more about that over at consumerwarrior.com. That's my main website, where we have all the information on the courses, the coaching that can help you if you're representing yourselves and allow you to save a ton of money in doing so. So that's going to do it for today's video. I appreciate you watching.